Hello, everyone. Welcome to our weekly live show on US immigration. In this show, we answer all of your questions regarding US immigration. However, unlike other week, today we will not answer your questions about US immigration. Rather, we will have a special talk on US immigration litigation. And to do that, I invited famous attorney Brian Green. He is a US immigration attorney and expert litigator. Brian and I, we will discuss about different aspects of U.S. immigration litigation. We'll talk about writ of mandamus. We'll talk about lawsuit under APA. So let's welcome Attorney Brian Green.
Good morning.
Good morning. How are you doing this today?
Good, Raju.
Great. So let's start with writ of mandamus. So can you please tell us what is writ of mandamus, how long it take, and like the other important things about writ of mandamus?
Sure. So a writ of mandamus lawsuit is essentially a lawsuit saying the government is taking too long to process an application, a petition. So you're basically asking a federal judge to tell USCIS or State Department, if it's a visa, that this case is taking 1 year, 2 year. It's too long. Anything longer than 6 months is viable as a delay for a lawsuit. And the length of time it takes for the case to be resolved depends a lot on where you file the lawsuit, which court you use. Could be California, could be Florida, could be Texas, could be New York, Virginia. Anywhere is possible, but some courts in some locations are far too busy. Like Washington D.C., they have tens of thousands of cases they're dealing with. If you sue in Oklahoma, you're probably going to get a much faster response. Also depends on what kind of case you're suing on. If you're suing on like an I-526, it might take longer. If you're suing over an EAD, an I-765, probably faster. But there's really no way to tell you exactly how long it takes. You have to look at averages. And I've done around 700 lawsuits in the last 2 years. And some of the fastest cases get resolved in 3-4 weeks. Some of the longer cases, I had several K-1s that were delayed in Afghanistan. Those took about a year because the U.S. Embassy in Afghanistan was down to maybe 10 or 15% staff. So those cases did take longer, but I tell people usually, 3 or 4 months is a good, estimate for those kind of cases.
Perfect. Thank you so much. By the way, dear audience, if you want to contact Brian directly, his website is www.greenusimmigration.com. If you go to that website, you will get all of the information about him. And he is licensed in a lot of US federal courts in different states. I frankly speaking, I never saw anybody licensed as many as federal courts as Brian. So no matter where you live, probably you'll see that Brian is licensed there. So www.greenusimmigration.com. Thank you, Brian.
Sure.
Can you tell us what kind of delay is covered? What kind of delay can be solved through writ of mandamus?
Pretty much everything. So I'm doing a lot of cases on visa delay right now. Sometimes it's a petition's approved but hasn't gone to National Visa Center yet. Other times it's at National Visa Center, but they're not scheduling the interview at the U.S. Embassy or consulate. That's hot right now. A lot of EADs, a lot of people, especially people that were H-4, those people had a long delay or have had long delays the last 2 or 3 years to get their EADs and advanced paroles. So those are very common lawsuits. I-45, if you're in the U.S., you filed your I-140 and your 45, you can sue over those, even if the I-140 has not been approved yet. But it's easier if the I-140 is approved and the 45 is pending. If it's longer than 6 months, you can file that lawsuit as well. What else can we sue over for delays? I-601s. I just had a lawsuit in California with 6 I-601s that were delayed. All 6 of them got adjudicated. I believe they all got approved. And we just withdrew the lawsuit, I think, on Friday. So 601s are a possibility. EB-5 cases. I filed lawsuits over I-526s. And also, I think is it I-829 or I-826?
I can't remember at this moment.
I think it's I-829. It's where you're removing the conditions from the green card after the EB-5. I have lawsuits pending over those. So anything that doesn't have premium processing, you can basically file a lawsuit over. I haven't one now. I just filed on an I-130. A chef in Guam is waiting for his wife. His wife is in Bali, Indonesia. and the I-130 has been pending now for about 2 years. So we filed a lawsuit over that. The only problem there is that the case was at the Nebraska Service Center first, and now the field office in Guam is involved. So they might transfer the lawsuit from Nebraska to Guam. I'm not admitted to to be admitted in Guam, you have to take the local bar exam. So if they transfer the case out there, I'll have to get a local lawyer in Guam involved. But most of these cases, again, resolve within the first 2 months, 3 months. But yeah, if you can think of a case type out there, I-360 for VAWA, I-918 for U visa applications, for literally any benefit you can think of, you can file a mandamus if it's been longer than 6 months. The longer the delay, the more likely you're going to have success on it. But I tell people not to wait. I tell people if they want to file the lawsuit, it's a good idea to do it now and see what happens.
Awesome. I see a beautiful cat. Is that your cat? What's his or her name?
This is Gabby. She's a rescue cat. I got her about 6 years ago in Maryland before we moved out to the West Coast. And now we're in Colorado. But yeah, she's like my paralegal cat.
And it's a Maryland cat. I live in Maryland. That's awesome. Yeah. Great. So let's say somebody applied for a visa. It could be non-immigrant visa. Let's say B1 or B2 visa in a foreign U.S. embassy in a foreign country, and they're not getting even interview scheduled. So can we file a lawsuit just to get an interview?
You can, absolutely. So if they filed it, I'm assuming NVC is not involved there. So yeah, you file the lawsuit, and typically you're going to get the interview scheduled, and then I don't withdraw the lawsuit until we have adjudication. So, it should work out. Cases where there are sometimes some complications are more like I-130s and sometimes I-140s. Sometimes the U.S. State Department officer will send back the petition and say, hey, USCIS, I think there's a problem. Go ahead and review this. In those situations, I sue everyone. I sue USCIS, Homeland Security, State Department, the consulate or embassy, sue everybody. And then that speeds the case back to USCIS. They will often reaffirm the prior approval, and it goes back to the consulate for the interview. And I've had people interviewed a second time. It's sad that it takes that much effort, but if they get their non-immigrant visa, if they get their immigrant visa, it's totally worth it. The only cases that are time sensitive really are diversity visa lawsuits. They expire if you got selected in the diversity visa, you expire at the end of September. So I had people contact me in the last couple of weeks, and I tell them it's too late right now. For those cases, you want to sue more like in June or May, and that gives enough time for the case to get worked out before September 30th. But yeah, any kind of visa delay is possible.
What about asylum? So let's say somebody applied for asylum and didn't get the first interview from the USCIS, or they got the interview, but USCIS is not telling them anything, not giving them result. Can they file? And did you do that before?
What was the type of visa?
Asylum application.
What's an SLM?
Asylum is like somebody, some people pronounce it like asylum or asylum.
Oh, so asylum, yeah.
Yeah.
Yeah, so you're talking about visa or in the United States?
In the United States.
Yeah, I think it's a 730 application. I've dealt with those as well. It also might be 589 application.
I think 589. Yeah,
589. Yeah, you can sue over those. The weird thing with that is the government used to go first in, first out. Then they went to most recent and try to get rid of cases. So it's very crazy. But yeah, you can absolutely file those if they're at the Arlington Asylum office. Those lawsuits are typically filed in Virginia. That's one of the places I'm not licensed, but I do work with local people. If you're admitted to the Eastern District of Virginia, we can do lawsuits through you. I also work with an attorney named Elizabeth Cola-Meyer. She's excellent. She's an Arlington AILA member. So yeah, absolutely. We can file lawsuits over asylum cases, VAWA, U visa, anything you can think of, delays. The things that you can't sue over are typically discretionary denial. So if you have a 485 that's denied, you may or may not be able to sue. It depends on what, or NIW. NIWs are very difficult to sue over because if they say, we reviewed your evidence and we think that you don't meet the national interest, then the courts are going to probably say, we're not going to review that. So in that situation, you're probably better off filing a new NIW case. And I do a lot of lawsuits over EB1, EB1A, EB1B, EB1C. and O1 visas, even I-140s for EB3. Those lawsuits are much easier to sue over because there's defined criteria that USCIS is supposed to use.
Okay, that's awesome. So yeah, a lot of people they call me about filing lawsuit, read mandamus for asylum cases.
Mhm.
Like they filed to I-589 to to USCIS, and
Mhm.
it's been like 4 or 5 years. They
Yeah.
even didn't get the interview, like the first interview. So.
Absolutely. Yeah,
Mhm,
those are viable. You can sue over N400 delays.
mhm.
If someone has an interview for N400 and doesn't get their oath ceremony, you can sue over that. So anything from asylum all the way through to naturalization, you can sue at every stage of the process.
Mhm. So what is the difference between writ of mandamus and filing lawsuit under APA?
Well, it depends on what you're challenging. The APA has a provision that says that delays that are too long are unlawful. So when I do a mandamus lawsuit, I sue under the Administrative Procedure Act and under the what's called the All Writs Act, a writ of mandamus request. I do both, but you also can challenge denials. And that's just another different section of the Administrative Procedure Act that says that if a denial is arbitrary, capricious, not based on law, if they said, well, we don't like you because you're from a certain country, if they break the rules when they're denying your case, you can sue over those too. So I call those APA lawsuits. Everyone calls a delay lawsuit a writ of mandamus lawsuit. Even the judges and the U.S. Attorney's Office all call it mandamus. But you can sue under either one. The denials, if you challenge a denial, you're probably going to hopefully win. You probably won't get any attorney's fees because most often USCIS will either reopen the case and issue an RFE or issue a notice of intent to deny. Or if they realize it's a really bad mistake, they'll just go ahead, reopen, and approve the case. I have had that happen with professors, in-house chemists for manufacturing companies, all sorts of people. But yeah, if you win, it's an egregious lawsuit, egregious denial. There is a chance to get attorney's fees, but I tell clients, don't bank on that. Assume you're not going to get attorney's fees. And if you're that 1% of people that do, you'll be very happy because you'll get back some of your costs. But the reality is that the government settles their worst cases and they fight the cases where they might win. If they might win, they're probably not going to get attorney's fees. But you can sue over I-130 denial, I-45, I-140, I-526. You name the case. The only ones you can't really sue over, like I said, NIW denial is difficult. I-601 denial is difficult. That's probably the only two you really have to worry about.
What about B1, B2 application, like denial from embassy? Isn't that covered under consular non? Forget the term.
Non-reviewability, right? The
Non-reviewability. Yes.
doctrine of, yeah.
Hmm.
So there's a case called Kerry versus Din
Hmm.
at the U.S. Supreme Court, and they said that U.S. judges in the United States are not going to be able to review denials made by the consulates or the consular officers overseas. So if you have a denial of almost any kind overseas, you're probably not going to be able to do a lawsuit. But those cases, you can work with a visa office in Washington, D.C. That's like an informal appeal. You can also go back to the consulate and refile and try to address the reason why they made the denial in the first place. So if it's a B1, B2, and the person's 22 years old, they have no connections to the home country, they don't own any property, they don't have a job or family, you're probably not going to win that one. But if it's something like an L1 denial or an H1B denial where it's clear that the job is good, the person has the qualifications, you could possibly do a lawsuit and maybe simultaneously file a new, DS 160 application. And in that situation, one of the two might result in a good, you might get an approval. But yeah, it's tough. It's easier to challenge denials inside the United States, even change of status in the United States. If you're changing from B1 to H1B, you can sue over that. Whereas the denial of the H1B or the B1, B2 be at the consulate, it's pretty difficult.
Yeah, and also another question. A lot of people ask me that if I file a lawsuit, against USCIS or U.S. Embassy in a foreign country or Department of State, Department of Justice, is that going to hurt me in the long run, in future?
No. If you're talking about USCIS, They're well, both. They're huge organizations, and they don't have a blacklist that they keep where people have sued and then they don't get a benefit. So if you're talking about suing USCIS and going for a visa interview in the future, those are two different federal agencies. They don't communicate on that level to know those details. And even if you're suing within USCIS, I actually think we get better treatment when we sue. And right now, people are suing for InfoPass appointments. If they can't get in to get a stamp on their passport, they can't get in for an emergency, they're filing a lawsuit. And then I had one where we filed a lawsuit in Baltimore at the USCIS office. I met the in-house lawyer. She met me at the door and she walked me in. We filed a document with the desk. And then she walked me out and said, thank you. And it was like VIP treatment. So I think it's the opposite. I think when you have a federal judge and a DOJ lawyer involved, you get a different independent review of the situation. So I think you actually get better treatment. I mean, you don't want to bring a bad lawsuit. That's not a good idea. But as long as your lawsuit is bona fide and has good basis, I would not worry about retribution. This is not, other than what you hear in the news, it's not really the kind of country where people are punished for using that judicial system.
Yes, yes, yeah, exactly. That's what I tell people, because taking help from judicial system is the part of what America is. Mm-hmm. So if you take any help from judicial system, that's not going to hurt you in any way.
Yeah.
Yeah. Now, I want to ask you a more like a technical kind of question. Mm-hmm. So, lot of time, for the question of venue, like where we can file lawsuit against USCIS. So, like most of the factor is in favor of DC. But sometimes, so let's say one scenario, the plaintiff, he's a H-1B visa holder. He was living in, let's say, California, but he went back to India to get the visa stamp. And now he's stuck there in administrative processing. So he's a citizen of India. He was in California under a H-1B visa. Now he is in India. So when I file lawsuit, let's say in Maryland, they said, oh, the plaintiff, or DC, let's say in DC, they say, oh, the plaintiff is domiciled in California, so the case should be moved to California. And my argument is, no, he's a citizen of India. He was here for a temporary visa, and right now he's in India too. So he's not domiciled in California. So how do you handle that kind of situation?
I don't file in DC unless I have to. I mean, I've been filing lawsuits in DC since 2007, but they are so overwhelmed with the January 6th insurrection cases. And also everyone thinks that DC is the best place to file a lawsuit for immigration. So right now it's taking 2 months to get an assistant U.S. attorney assigned to your case. So if it's a delay case, DC makes it longer. And after 2 months, they might then say, yeah, we're going to transfer this case to California. And the judges in DC are going to say, yes, they're going to transfer the cases out. The only time that it really works for DC is when someone's never been in the United States. They don't have a domicile. They never had an apartment or a house or something in California. Then DC probably would work. And then for USCIS cases, the USCIS headquarters moved to Maryland in late 2020. But even there, the judges are transferring cases all around the country to get rid of them. They don't want them in Maryland. So for me, I would just go ahead and file in California, and I have local attorneys. I have a guy named Rajesh Prasad in Southern California, ALA member. And in Northern California, I use a good guy named Samir Kedekar. He's in the Silicon Valley area. The thing about California is it's a very liberal set of judges. So California is better than DC. DC has a fair number of Trump-appointed judges now. So a Trump-appointed judge named Judge McFadden, Trevor McFadden, he denied a mandamus case where a visa had been pending at the U.S. Embassy in Moscow for 3 or 4 years.
Wow.
And he said that's not unreasonable. COVID, problems with staffing, Russians were kicking out U.S. diplomats. So if you file in D.C. and get the wrong judge, you might completely lose. So in that situation, California is better. I also would look and see where is the H-1B employer based. If the H-1B employer is based in Dallas, Texas, and the worker was in California, you could sue in Texas, you could sue in California or in DC. But DC is not recommended and hasn't been for a couple of years now. If a visa is delayed at the National Visa Center, I'll sue in New Hampshire, where the National Visa Center is located. If a case is delayed at a USCIS service center, I'll sue in Vermont, Nebraska, Texas, Potomac, and Virginia, California. So I typically sue where the person lives or where the case is physically pending.
Got it. Yeah.
There's usually 3 options for venue, and you might have 1 or 2 that are better. So it's a case by case analysis to see which one you think is the best. But I don't only limit my practice to where I'm already admitted. If someone needs to sue in Seattle, if someone needs to sue in Minneapolis, I just work with an AILA lawyer that's based there, and that helps me practice around the whole country.
Yeah, that's true. And I'm a member of AILA, and I'm also a member of another organization. It's called NILA, National Immigration Litigators Association, and NILA is also a very good resource to find lawyers in local area.
Absolutely.
I remember NILA.
Not yet, no, but I probably will look at that today.
Yeah, I met a lady in AILA conference in New York. She was really nice, and she helped me being member.
Cool, yeah.
Yeah, cool. So we are almost end of the session today to discuss about immigration litigation. Is there anything you want to add? You want to say anything to our audience?
Yeah, no, I think you covered most of the points. The idea is to not be afraid of litigation. I would probably talk to lawyers and find out what their fees are, what their time frames are. For me, if someone hires me and my co-counsel, I try to get lawsuits filed within 2 to 3 weeks after receiving the payment and the signed retainer agreement. Some people may do it very fast and may not do a very good job. Other people might take a month and a half and they might make a Picasso or a symphony by Mozart. You don't have to do, your lawsuits don't have to be 500 pages long, but you need to know what the lawyer you're hiring, you need to know what their track record is, their experience level, and why they're choosing the venue like you talked about. I file a lot of lawsuits in Vermont and Texas. I have local lawyers. We have amazing results. I think we filed with my just delay lawsuits. I think I'm up around probably getting close to 600, 650 lawsuits in the last 2 years. And I think we resolved around 98, 99% of them. So the track record I have with my co-counsel is amazing, but we also don't bring cases that have been pending for 3 months or 2 months. If you bring cases that are too short and in the wrong court, you might lose on motion to dismiss. I've had that happen only once. And unfortunately, my co-counsel didn't tell me the visa got approved. So if he had told me that, I would have withdrawn the lawsuit. I would not have lost that case. So in that case, I won. But in the court system, there's a denial on the record saying that the delay was not too long. That was someone, I think, in Ghana or Nigeria. It was someone in Africa coming to live with their spouse in Texas. So I would just be careful about who you hire, shop around, talk to 2 or 3 different lawyers. And people will come to me and they'll say, well, I've contacted a U.S. senator. I've contacted a U.S. congressperson. I've asked the USCIS ombudsman to get involved. Those are all great ideas to do. They'll come to me and ask me, what's the time frame? What's the cost? They'll say, well, I'm going to come back to you in a month or 2 months. And I say, great. Okay, you know what the plan is. You know what the costs and the details involved. Just don't wait too long, because with some cases like the diversity visa, they're going to run out at the end of the fiscal year. Other cases depends. If you're an H-1B worker and you're stuck overseas, when is your employer going to stop bringing you back? When do you lose your job? That's the critical deadline there. And with lawsuits, you're talking about filing a lawsuit takes, say, 2-3 weeks. The government gets 60 days to reply. So you're up to around 3 months at that point. And then it might take a month or 2 after that to get a resolution. So if you're looking at lawsuits, you need to be looking 2 to 5, 6 months down the road. And so you need to be filing a month or 2 before you really need the visa, or maybe even 3 months before you need to have the visa. So I would ask questions early and then make your decision based on that.
Perfect. Thank you so much, Brian. And before we finish, I'm telling your website again. Hello, everybody. So Brian Green's website is www.greenusimmigration.com. So feel free to reach out to him. Also, if you need to reach out to him, you can reach out to me through me. Brian and we work together in different cases. So thank you so much, Brian, for joining today. And hopefully we'll do another session later about other kind of stuff.
Hopefully we can do some lawsuits in the Eastern District of Virginia very soon.
Perfect. Yeah, we'll do that together.
Okay. Thanks for having me on your broadcast.
No problem. Have a wonderful day.
Yep. And Gabby the cat says hello.
Hello. What's his name?
Gabby.
Gabby. Hello, Gabby. Yeah. We are from Maryland too.
Yeah. All right. Take care, everybody.
Okay. Bye.